I'm Robert Fleming. I'm a private attorney operating in Tucson, Arizona. I'm a member of the National Academy of Elder Law Attorneys for years and years, and I'm a certified elder law attorney certified by the National Elder Law Foundation. I'm here to talk to you about the administration of special needs trusts. Administration of special needs trusts as distinct from how to create special needs trusts, what are the circumstances where you might create a special needs trust, what are the drafting considerations, what specific provisions might you include. But once a special needs trust decision has been made and the special needs trust has been created, what kinds of administration questions come up for an elder law practitioner. In a general way, we can probably categorize most of the administration questions into two headings, but there are some other issues as well. The two primary considerations that we're going to talk about are making decisions about distributions from the trust and the tax treatment of the trust. In order, however, to talk about the first of those, the distribution standards, we have to start with a generalized understanding of public benefits programs. And I'm not going to try to teach you all about public benefits, and I'm certainly not going to try to teach you about planning considerations. But we do have to, for how to get eligible for public benefits, but we do have to have a basic understanding of how the public benefits systems work and how a special needs trust distributions might affect the eligibility for public benefits. So let's look at a couple of different categories of public benefits. First of all, one big distinction is between public benefits programs that are not means tested and those that are means tested. And we can talk about a lot of different individual programs, but in very broad brush strokes, the two most important non-means tested programs usually are Social Security Disability and Medicare. Now, of course, Social Security retirement and civil service retirement and benefits from the Veterans Administration might all be characterized as public benefits that are not means tested, but those aren't the ones that drive most of the decision making about special needs trusts. They are disability, Social Security disability, and Medicare. Social Security disability is not means tested. You don't have to prove that you have limited assets in order to receive Social Security disability, but you do have to establish that you're unable to perform any substantial gainful employment, that you are completely disabled. Not just disabled so that you can't do your usual job if you had training before your disability, but you have to be unable to perform any substantial gainful employment. And then once that's established and you've established your eligibility for Social Security disability, which flows either from your own work history or the work history of a parent or someone else who has supported you, then you don't have to establish that you also don't have any assets or income in order to receive Social Security disability. It's just eligibility for the program and inability to perform substantial gainful employment. Once you've established eligibility for Social Security disability, 24 months later, in most circumstances, you become eligible for Medicare, which will cover the bulk, not all, but the bulk of your medical needs. And so if you become disabled while you're covered by a Social Security wage earner, yourself or a family member who's been supporting you, then you won't have to ever establish that you have limited assets and resources in order to qualify to receive both cash from Social Security disability and medical care from Medicare. And consequently, the whole special needs trust arena is not going to be as important for you. Contrast that with the means-tested public benefits programs, notably SSI, Supplemental Security Income, and Medicaid. And it's kind of unfortunate in a way that SSI has such a similar acronym to SSD, particularly since SSD is sometimes called SSDI, Social Security Disability Insurance, is a completely different program from SSI, Supplemental Security Income. And so people are often confused about which program they're on, or they're confused about which program their children
receive benefits from. And it's very difficult sometimes to figure out whether they're in a means-tested program or not based on what you're told by clients who live in the system but don't appreciate the fine distinctions between different kinds of programs. Nevertheless, in order to receive SSI, Supplemental Security Income, you have to have a disability, the same disability standard that is applicable to SSD, or Social Security Disability. And in addition, you also have to be poor. And the definition of poor is something we're going to talk about in a minute. But you have to have both an asset limitation and an income. You have to be below an income level in order to qualify for SSI benefits. In most states, but not all states, once you get eligible for SSI, you automatically qualify for Medicaid. Even though Medicaid is a state and federal cooperative program, the federal rules require states to either automatically extend Medicaid to SSI recipients or to have opted out years ago. And so most states do categorically make SSI recipients eligible for Medicaid. In those states that do not, the Medicaid eligibility rules look very much like SSI rules. They won't be identical, but they'll be very similar. So we can talk about SSI financial eligibility rules and pretty much cover the Medicaid waterfront at the same time. It's kind of unfortunate, as with SSI and SSDI, that Medicaid and Medicare have such similar sounding names, because once again there's a lot of confusion among participants in the various programs about which benefit they're receiving. And in fact, it's entirely possible a lot of people receive both Medicare and Medicaid benefits, and for that matter, a fair number receive both SSD and SSI benefits, and so that complicates the effort to tease out what kind of programs people are receiving their benefits from. So both SSI and Medicaid have means tests that are similar, and in a second, as I say, we'll kind of go over the broad brushstrokes of what those standards are. In addition, however, there are several other means-tested programs that you need to be aware of and have in the back of your mind that may have more or less significance for individual clients or the disabled child or family member of a client who's consulting. Those benefits programs include housing subsidies, mostly federal housing subsidies, and food and nutritional supplement programs like TANF, the Temporary Assistance to Needy Families, which used to be called Aids to Families with Dependent Children, and that's what it's often more commonly known as, or food stamps. And so you have to be aware of those eligibility standards. They're a little bit different from the Medicaid and SSI standards, but in a general way, the most important standards to keep in mind when you're looking at eligibility considerations are those SSI standards. Even for somebody who's not on SSI, very similar standards are going to be applied for Medicaid and all of their other eligibility programs. So now, with that background, how do you make a determination about whether to make a specific distribution? If you, as a lawyer, have been consulted by a special needs trust trustee, or if you are the trustee of a special needs trust, how do you make a determination about whether to make a specific kind of distribution that has been suggested? It's very common for lay people to talk about, I have a special needs trust and therefore I cannot have the following things. And that's usually not the case. There are very few things that can never be done by a special needs trust. And often it may be that you can't do it in a particular way, or there are limits to the amount that you can spend on some kinds of things. But before we get to the public eligibility programs, we've got a couple of stops to make along the way. And the first one is, what does the trust document itself say, regardless of whether the special needs trust was set up by a third person, a parent or a grandparent or a family member who wanted to leave money to a beneficiary who has a disability, or whether the trust was set up as a self-settled trust, in other words, a trust that is funded with, for instance, the unrestricted inheritance or the personal injury settlement received by a beneficiary who receives public benefits. regardless of which kind of trust it is, the document might contain restrictions. Maybe they didn't need to be in the document, maybe they were unnecessarily restrictive, but the document might contain restrictions on the kinds of distributions that are to be made. Or it might include general grants of authority that compel distributions regardless of the effect on public benefits eligibility. In a poorly drafted special needs trust, for instance, that might compel distributions for the support of the person or for their rent, which might cause some problems with public benefits. But the first stop to look at is the trust document to determine whether the proposed kind of distribution is either compelled or prohibited by the document. A lot of special needs trusts, not by any means all of them, but a lot of them are court supervised. And how do special needs trusts get to be court supervised? Well, commonly, not the only way it can happen, but commonly, self-settled special needs trusts established with personal injury settlement money, for instance, are done in the course of a guardianship of the estate or a conservatorship proceeding in which the continuing eligibility for public benefits is seen as a positive for the beneficiary. And so a court has approved the creation of the trust. And pretty commonly, courts across the country, when asked to do that, take the position that the trust is effectively a substitute for the guardianship of the estate or the conservatorship of the estate that would otherwise be in place for a person who is unable to manage their own affairs. And so the court is going to compel the trust to operate as if it were a conservatorship or a guardianship of the estate. And that commonly will mean annual accountings. Maybe it'll require the posting of a surety bond. Maybe it'll require notice to specific individuals. And so not always, but pretty commonly, in addition to looking to the trust document, the trustee has to consider what the reaction of the court is going to be in the next annual accounting cycle about whether the distribution is going to be approved or not. So that's a concern to keep in mind. Even in a case in which there is no court supervision, of course, in most states there is a court, the probate court or some court of general jurisdiction, that has primary jurisdiction over the administration of trusts. And any person who objects to the distribution or wants to compel a distribution, any interested person at least, could bring a proceeding in the court to either prohibit or compel a particular jurisdiction. They may not prevail, but the standard that's going to be applied is a judicial standard. So even in a case in which the trust is not supervised by the court, it's certainly prudent for the trustee and the trustee's attorney to keep in mind that someday some judge may be looking at this distribution and determining whether it was an appropriate use of the funds and analyzing the size of the trust and the amount of money being asked in the distribution and the relationship between the trustee and the beneficiary and other sources of assets and income and all the things that a judge is likely to look at, whether the trust document compels all of the implementation of all of those standards or not. At least in cases of self-settled special needs trusts, those trusts that are funded, again, primarily with personal injury settlement money or sometimes unrestricted inheritances that are placed in a trust after the death of what would be the settlor, the person who left the money. At least in those cases, many states have either Medicaid regulations or even state statutes that limit the kinds of expenditures that can be made. A lot of those states require that the limitations be written into the trust, but not all of them do. And so in addition to looking to the trust document and looking over your shoulder or the trustee's shoulder at what the court might approve after the fact, prudent course is to also look at the statutes and see if there's any guidance or prohibition in state law in order to determine whether a given proposed distribution ought to be made. That's probably only going to be an issue in self-settled trusts. It's uncommon for state statutes or regulations to dive too deeply into third-party trusts, but that's something to also keep in mind in analyzing a distribution or proposed distribution. And finally, after all of those other considerations are looked into, then and only then it's appropriate to consider what effect the proposed distribution is going to have on the eligibility for continued public benefits of the beneficiary. just because the trust distribution might cause a reduction in benefits or even a suspension or an ending of the benefits, that doesn't necessarily mean that it can't be done if the trust language, the document itself, permits it, and it's in the best interest of the beneficiary. It might well be appropriate to reduce or even eliminate public benefits. But the trustee certainly has to have a generalized understanding of those benefits, what they are, what benefits is this beneficiary actually receiving, and what effect will my proposed distribution have on those benefits. Now, I don't want to imply by that the trustee is in charge of reporting the distribution to the public agency or monitoring the receipt of public benefits. The trustee's job is to manage the trust and to make reasonable, prudent decisions about proposed investments and expenditures and distributions. The trustee has to keep in mind what the public benefits arena looks like, but the trustee is not in charge of the public benefits, unless the trustee also happens to be the payee for public benefits programs and actually has signed something indicating that they will keep the agency informed. That said, there are at least some states in which the Medicaid agency may require the trustee, once they learn of the trustee of at least a self-settled special needs trust, may require the trustee to sign some document by which they agree to provide periodic accountings to the Medicaid agency. And obviously, if a trustee has signed agreeing to do that, and even if that signature is made just to make sure that the beneficiary continues to receive benefits, well, the trustee has now undertaken an agreement to report distributions to the beneficiary to the public benefits agency and needs to comply with that. All right, so now we've got a proposed distribution. We know what the benefits programs that the beneficiary is actually receiving. We need to figure out what effect it's going to have on the benefits. In order to do that, we have to kind of look at the eligibility standards for SSI. And as I say, the eligibility standards vary for the other programs a little bit, but we're going to primarily focus on SSI, both because it's the most important public benefit program for most beneficiaries of special needs trusts, and also because the other benefits programs tend to have their eligibility standards modeled on the SSI rules, even though they may be a little bit different. So in addition to requiring that you have a disability and that you be a citizen or legally in the country, and the other eligibility standards for SSI, there are two means-tested standards that they apply. One is an asset standard and the other is an income standard. SSI has this charming distinction between assets and income. If you receive money this month, it's income. If you still have some of it on the 1st of next month, it just turned into an asset. And that's about as sophisticated as the definition in SSI is. The asset standard is almost in our DNA at this point. It is so well understood. The numbers haven't changed in years since the beginning of the program. And everyone who receives public benefits is very familiar with the basic asset rules, which are a single person can't have more than $2,000 in available resources. Not counted in available resources are about 8 or 10 different kinds of resources that are exempt from consideration. And some of them are a little bit obscure, but the important ones are, in addition to the $2,000, you can have your home, you can have one vehicle, you can have your household furnishings, you can have property that's used in your trade or business, and you can have a small amount set aside for burial. And that number varies a little bit depending on exactly how it's done, but let's just call it for the moment a small prepaid burial that you can have in addition. That's it for a single person. For married couples, the rules are a little different. For married couples, the income rules are a little different too, and I'm not going to spend any energy on those. If you have a circumstance where the trust beneficiary is married, be aware that the rules are different and you're going to have to do a little bit more digging to figure out precisely what effect the proposed distribution is going to have. We're going to talk primarily about a single individual because that's the only way to keep the rules manageable for purposes of discussion. So you have $2,000 of available resources, your home maybe, and that's home and contiguous property, so maybe you have a mobile home sitting on a lot, maybe you have the adjacent lot, maybe you have a big house, but whatever assets you have, that's it for SSI purposes. And then they look at income. And the way SSI determines your income eligibility is first by setting the maximum federal benefit rate. That's a number that changes every year, and it increases along with the cost of living adjustment for Social Security generally. And it's also the maximum SSI payment. So the maximum federal benefit rate is the income standard against which SSI recipients are measured. Basically, if an SSI recipient's income is less than the maximum federal benefit rate in the year in which he or she has applied for eligibility, he or she will receive SSI, and they otherwise qualify, of course, he or she will receive an SSI check of a sufficient amount to get them up to the maximum federal benefit rate. And actually, they get to get $20 more than the maximum federal benefit rate if they have any other source of income, because SSI ignores the first $20 per month. So you look at the maximum federal benefit rate, and some number between that and $20 over it is the maximum income that an SSI recipient can receive. In that definition of income, as I said, pretty much anything you receive in this month is treated as income in this month. But in addition to wages and stock dividends and interest payments and all of the things that are obviously income, SSI treats any cash that you receive as income, so a gift from your mother is income, as well as anything that can be converted into necessities, food and shelter, as well as food and shelter itself. So if someone provides food and shelter for you, that will be treated as income. If someone gives you gift cards that could be cashed in and turned into food and shelter, even though you don't, even though you take your gift card down to the gas station and buy gas for your automobile, which you're permitted to do, even though you did the right thing, the fact that you could have taken that gift card over to a place that sells food or to redeem it and paid your rent with it, the mere fact that you could have done that will cause that to be treated as income. But the kind of interesting category here is those things that are direct support and maintenance. In other words, direct food and shelter. As I said, they're treated as income. If someone pays your rent for you or brings you a big bag of groceries, then that's treated as income for you, but it's handled a little bit differently. So if the parent of a child who is receiving SSI hands the child a $50 bill and says, go buy groceries, that will be $50 of income. But if they hand the child $50 of groceries, it will be treated differently. So there's a premium on letting the parent or the donor or the trustee of a special needs trust provide the services directly rather than handing cash, gift cards, or any other kind of mechanism to allow the beneficiary to make the purchase. And that gets us to the notion of in-kind support and maintenance, because that's what SSI says any distribution of food or shelter themselves is. That's in-kind support and maintenance. It's not counted dollar for dollar. I'm going to explain how it's counted in just a minute. But first we're going to figure out what kinds of things are in-kind support and maintenance. So once again, the parent or the trustee hands $50 or a gift certificate or a debit card, prepaid debit card with $50 on it, and says, use this for food. It's treated as cash regardless of how it's actually used. If they hand that same debit card, credit card, whatever it is, to the beneficiary and say, use this for clothing, it's still counted as cash even though they even though the beneficiary actually does use it for clothing, because clothing is a permitted distribution. If what the trustee or family member does is hand $100 worth of clothing, it has no effect because that is not in-kind support and maintenance. If what the trustee or the parent does is to repair the beneficiary's roof, that has no effect because even though that's payments toward their housing, it's not counted as shelter for purposes of calculation of in-kind support and maintenance. So pretty much anything that is paid directly to the vendor rather than to the beneficiary does not have any effect on the public benefits eligibility unless it's in one of the categories of in-kind support and maintenance. Social Security has given us a list of what they think constitutes in-kind support and maintenance. It's a 10-item list, and if it's not on this list of 10 items, which as you go over the list you'll realize is actually 11 items long because of a special footnote to one of the rules. So if it's not one of these 11 items, then and it's directly provided rather than cash being provided, and it can't be traded back in for cash that could be used for food and shelter, then it has no effect on the public benefits eligibility. And in a minute, I'll kind of point out the kinds of things that leaves open for distribution. The 10 items that amount to in-kind support and maintenance, again, the significance of this list is if a third person, including the trustee of a special needs trust, provides these items to a recipient of SSI, it will have an effect on their SSI. And we'll talk again in a minute about what that effect is. Here are the 10 items. Food, obviously. Mortgage payments, rent, property taxes, heating oil, gas, electricity, water, sewer payments, garbage removal. There's 10 items. 2 special rules. One is that homeowners insurance can be counted as in-kind support and maintenance, but only if it's required by the mortgage lender as a condition of continuing the mortgage. So that effectively becomes an adjunct to the mortgage payment. If there is no mortgage or the mortgage lender doesn't require homeowners insurance, then homeowners insurance is not food and shelter, is not in-kind support and maintenance, and can be paid by the trustee or a third party with no effect. And the other special rule is to the extent that homeowners association fees, condominium fees, or something like that covers things like garbage or water, they will also be counted as in-kind support and maintenance. A lot of homeowners associations, you pay $100 a month, of which $30 goes to garbage removal and sewer connection, or some numbers like that. And in that case, that would be $30 of in-kind support and maintenance that's provided by the third party if they paid the homeowners association dues. So if one of those things happens, then you have in-kind support and maintenance. What's the effect of having in-kind support and maintenance? Well, the effect is the presumed maximum value rule, because we would not want to have a system that was understandable and that didn't have a lot of acronyms. So once you have ISM, then that triggers the PMV. And the presumed maximum value rule says, look, what we're going to do is we're going to basically assume that the value of all of the in-kind support and maintenance that you provided to this person who receives SSI was no more than about 1/3 of the maximum SSI payment, the maximum federal benefit rate. So we're going to divide the current maximum federal benefit rate by 1/3, and we're going to add $20 because of that $20 disregard on the first $20 of income. And actually, you could argue that they should subtract the $20, but don't waste your breath arguing, and don't try to rationalize this calculation too much. It's just what it is. You divide 1/3, you divide 3 into the maximum federal benefit rate, add $20, and that is the presumed maximum value rule. And now the effect of in-kind distributions of food and shelter is to reduce an SSI recipient's SSI payment by the lesser of the actual value or the presumed maximum value. In other words, in my fact pattern that I gave you a few minutes ago, where mom gives a $50 grocery bag, a bag worth $50 full of groceries, to the beneficiary, that'll actually reduce his SSI, if that's all he receives that month, by $50. Well, okay, it'll reduce it by $30 because the first $20 is free. But otherwise, it'll have a pretty direct distribution. But on the other hand, if mom in that same scenario pays $50 for groceries and also $500 for rent, then the presumed maximum value rule calculation is going to kick in. And after that, anything that mom spends on food and shelter is going to have no effect because we've hit the presumed maximum value. Be very careful to appreciate that this only applies to in-kind distributions. If mom pays the rent, $500 worth of rent, and also hands her disabled son $50 and says buy groceries, that's $50 of income because that was done in cash. But if she buys another $50 worth of groceries and drops it off, then it will have no effect because the presumed maximum value has already been reached. And so it doesn't matter how expensive the rent is or how much is included in the room and board at a group home, what other services are included. Once you hit the presumed maximum value, there's no further effect. And that is a critically important element of the administration of special needs trusts, because it's very possible, in fact commonplace, for a trust to make provision for food and shelter directly and to trigger the presumed maximum value rule through the provision of in-kind support and maintenance without eliminating the SSI payment and therefore not knocking the beneficiary off of Medicaid. It's a common scenario, particularly in third-party special needs trusts. So ratcheting back to what do you have to calculate, what do you have to consider when making a determination about whether to make a given distribution? Well, you have to figure the effect on the beneficiary's public benefits eligibility using the in-kind support and maintenance calculation and the presumed maximum value rule, and then make a determination whether it's appropriate for the trustee using the distribution standards contained in the trust document to have that impact on the beneficiary's SSI and other public benefits. Enough about making distributions as a part of the administration. Let's just say a couple of words about the taxation of special needs trusts. Much has been written in this area, but it's actually pretty straightforward. Because of Internal Revenue Code Section 673, every self-settled special needs trust is going to be a grantor trust. Why is that true? It's because Section 673 says to the extent that the trustee can make any distribution to or for the benefit of the original grantor of the money, then they'll be treated as having fully exercised that discretion. And if that amounts to more than 5% of the value of the trust, then there's a reversionary interest that will cause this to be a grantor trust. And I submit pretty plainly, there is no self-settled special needs trust ever written that is so restrictive that you can't distribute 5% of the principal for the benefit of the beneficiary. And so let's just give it up and not spend a lot of energy on it. Self-settled special needs trusts are grantor trusts in every instance. I have yet to see one that is not plainly a grantor trust. And that means that you don't actually have to get an employer's identification number for the trust at all. You can use the beneficiary's Social Security number. You can get an EIN. You're not required to. You can. If you do, this tax return should simply say, I'm not reporting anything under this trust EIN because this is a grantor trust and all of the income is being reported on the grantor's Social Security number. And people who say, oh, but I like to file a trust tax return and take the administrative expenses, not permitted. It's a grantor trust. It files no tax return except for the information that everything is being filed under the SSN of the grantor. Third-party trusts are a little bit more complicated. They probably aren't grantor trusts to the beneficiary, but that doesn't mean they can't be grantor trusts to the person who originally set up the trust. And that opens up the door for consideration of intentionally defective grantor trusts. A special needs trust that is funded with money from a parent or a grandparent or someone who wants to get money out of their estate, who wants to benefit a child with disabilities, and may want to go ahead and pay the income tax on the earnings of the trust. So you can draft such a third-party trust in a way that completely removes it from any control of the original grantor and makes the trust a separate tax entity. Or you can draft it in a way that allows the original grantor to be the grantor for income tax purposes and to pay the income tax. And that's a decision you're going to make at the drafting stage, and there are a couple of choices for you. There are a bunch of other administrative questions that come up, and I'm just going to glance at them and not try to deal with them in any detail here. Who's the beneficiary of a special needs trust in which the state is entitled to a payback of everything they paid for Medicaid during the primary beneficiary's life? Is the state a beneficiary, or is it just some kind of a creditor of the trust? Different states take different positions on this, and that's going to raise a question of whether you have to give accountings to the state. Are they entitled to accountings as a beneficiary? Do you have to give notice of everything you do? And what about the trustee's duty of impartiality? How is that affected by a determination of whether the state is a beneficiary or is just some kind of creditor? Court supervision, I already mentioned, is a common problem to deal with in especially self-settled special needs trusts, and is going to affect the administration of the trust. And then, and it's kind of a whole separate area of discussion, but the trustee needs to be thinking about what's going to happen when the beneficiary dies. What can be paid from the trust? And the answer is going to be very different for self-settled special needs trusts and third-party special needs trusts. The trustee needs to do some planning to make sure that that those considerations have been accommodated in advance, and needs to be aware of what's going to happen upon the death of a beneficiary. That's what I wanted to tell you about the administration of special needs trusts. I hope that's been helpful. Thanks.